United Nations Special Rapporteur on the Right to Education. Okay, we are also welcoming Ramesh Kumar Verma. Thank you.
Good afternoon. It's a privilege to be here among you for today's session. And the theme, of course, is very, very important in the modern world for economic development and technological integration and human progress. When we talk of intellectual property rights, we should, I think, bear in mind, first of all, that the system as conceived conventionally centers around human rights. It is with a view to protecting human rights of the creators, artists, scientists, and those engaged in literature to protect their work. And this is very, very clearly reflected in UNESCO's convention, UNESCO's Universal Copyright Convention adopted in 1952 by UNESCO. The idea of that convention was to harmonize legislation and try to ensure that the rights of creators are encouraged and internationally circulated so that the literature, scientific and artistic works are known in uniform fashion, and they created, of course, the logo of which we see in all the copyrighted publications. And then the doctrine evolved to say that computer programs and other types of software, including mobile apps, are protected not as patents but as literary works for copyright purposes, because there is a human hand as behind that for creating these works. And the copyright, therefore, protects the original work of the authorship as such. The creator of the work is the person who obtains the right over the original work, and the question of computer programming, therefore, is software and application is settled. However, the developments in artificial intelligence, digital technologies and artificial intelligence have been, as we all know, explosive. And today we are living in a world where there is almost everywhere, in any sector of social life, personal or economic life, there is indispensable need for resorting to digital technologies. There have been a number of concerns raised on digital technologies in terms of its both the positive, the promises and the perils, because it is a human creation which has become a human monster when it comes to the imagined heights of artificial intelligence. And the challenge before humanity is how to keep upper human hand over the human monster. You must have heard the concern even by the progenitors of artificial intelligence over how it could be a big risk for humanity as such. And therefore, we must take into consideration the fact, as I mentioned, that we are living in a virtual world, but that virtual world could be both virtuous as well as vicious. And therefore, the intellectual property rights, when we try to evolve them to respond to these challenges, must cope with this fostering what is virtuous while trying to minimizing or even putting a ban on what is vicious. I think that this is necessary because the distinction between human-centered creation and machine-centered creation has blurred. Today, it is possible to protect, of course, as I said, human creativity, even if it is neural fashion, That is to say that somebody worked for hire, somebody was hired to work for a company and created some invention or whatever for intellectual property device, and that is protected. But the concern is when the machine themselves become automated way of thinking like human beings, creating like human mind, because of their big data and other devices, thinking on their own in terms of the property rights. I think there have been a number of concerns about this, and one of the important areas is how we can try to distinguish between the whole arena of conventional intellectual property rights which are protected and that infringement by way of big data and all these explosive artificial intelligence developments which are not acceptable when we call a fair use. UNESCO, for example, raised this concern long back, at about 2 years back, in 2022 by Media World Culture Conference, where I read from the text of the declaration that the accessibility and vulnerability of cultural actors, institutions, sites, and markets undermine intrinsic value of culture as a link between people and sources of income, structural impact of digital transformation on societies and cultural sector affects the cultural industry and access to cultural goods and services, and therefore they called for a better system for fair remuneration of artists, cultural professionals, and practitioners so that the system becomes fair, and also raised the concern of the vast inequalities in the concentration of global cultural platforms. I think that is the reality. And this reality is manifest in the fact that there are huge areas of infringement which are implicit, which is very difficult to prove, which are source of what is being created by big digital giants today. And therefore, I would simply suggest for your consideration something like centered around 3 P's for the purpose of developing future-oriented copyright system. This is because we know that, for example, and this is my view, I have been writing about it, the digital technologies, and particularly artificial intelligence, they are inherently, first of all, dehumanizing. There is one book which you must read probably, that is Nicola Carr, who wrote What Does Internet Do to Our Brain? And he said that international shapes the faculty of contemplation and concentration, and our very meditative thinking, which is the essence of human intellectual faculty and creation, is undermined. And that is very true because when you strike at the roots of human creativity and intellectual capability by way of artificial devices, then you minimize humanity to that extent. And this dehumanizing impact is more clearly manifested in artificial intelligence when you look at neurotechnologies. Some device can be put in your brain and it can evoke negative and positive effects. And one Nita Harnami from US, she wrote a book, The Battle for Your Brain. That is, say, we must save our cognitive liberty and our brain from onslaught of digital technologies and particularly neurotechnologies. And therefore, I think what we need to do is, we need to think in terms of, as I said, 3-pronged intellectual property system. One would be, we should try to be prescriptive. Prescriptive would mean that governments lay down prescriptions, like it has been the case for the purpose of intellectual property titles and rights. Other part of it could be permissible or non-permissible, depending on the technologies, and finally prohibitive, that certain kind of technologies are not allowed. The permissible use of technology in education, for example, is extremely important as long as virtual does not become vicious, and there have been a number of studies on that. The prohibited areas are, as I said, hacking and manipulation of thought, bias mimicry, etc., mind control, and the whole or almost doing away with the possibility of one's cognitive liberty. You must have read intellectual property, artificial intelligence and the concern that has been raised with biological or bacteriological weapons and lethal autonomous weapons system. And these are the dangers that I mentioned, and they are particularly considered very important in terms of the national sovereignty, cyber sovereignty particularly, and also the questions relating to terrorism and a number of other issues in that aspect. An American president signed a decree in October 2003 aimed at regulating technology, this kind of monster, and I quote, to fulfill the dreams of artificial intelligence and avoid the risk, we must regulate technology. That was his plea. This, therefore, the question of machine learning, automation in education, all that requires to be prohibited as such. As far as permissible technologies are concerned, I have already given you an example, but we must make a distinction also here in different domains or different dimensions of artificial intelligence and digital devices. For example, when it comes to fintech, industry or finance, we are totally in different world as compared to when it comes to what is known as edutech, the world of education and artificial intelligence and digital devices. You must have also read a lot of concern that has been raised by this chat bot and all that as to how in assessment of students there is a question of fraud and all kind of other issues, plagiarization and that what is not permitted and what could be not even acceptable to introduce. In fact, I believe, and I read a number of articles, that the children, right from beginning, as regards education, should not be induced to, in totality, to depend on tablets and other artificial digital devices. They must have the human touch, play, and what is necessary for bringing their potential. And therefore, UNESCO called, the United Nations Secretary General called what he called World Summit on Education. And he started with UNESCO. There was a pre-summit held. I was also there September 2022. And the idea was how do we try as regards education to ensure that the digital transformations do not have any effect which is not acceptable in terms of human rights and many other concerns. And this led to what is known as Gateway in Public Digital Learning Initiative launched by UNESCO and UNICEF, where they said that as far as education is concerned, we should try to rely on the concept of digital technology as common good, which would mean in terms of intellectual property that there must be by way of either open resources in education or compulsory licensing or some kind of system, free access and universal access to education resources worldwide promoted by United Nations and specifically by UNESCO and UNICEF. And I am trying to give you this dimension particularly because I think when we think of digital technologies and copyright or intellectual property rights, and particularly artificial intelligence, we must bear in mind the international framework which is evolving. There are a number of declarations which have been made and recommendations. For example, UNESCO made a recommendation on ethics of artificial intelligence in November 2021. And that recommendation clearly lays down the responsibility, social and human responsibility of artificial intelligence companies, big giants, to respect the human rights and all other aspects relating to international law. And the objective of recommendation are to provide a universal framework of values, principles, and actions to guide states in the formulation of their legislative policy and other instruments relating to artificial intelligence. Similarly, you must have heard also of Global Partnerships for Artificial Intelligence, which was a follow-up to the call given by the French President Macron at the Global Forum on Artificial Intelligence for Humanity, and that was the concern, which was organized in Paris in October 2019. And at that summit also, it was recommended to adapt this global framework to support responsible and human-centric development and use of artificial intelligence in a manner consistent with human rights, fundamental freedoms, and our shared democratic values. I quote from that summit which I mentioned, Global Forum on Artificial Intelligence for Humanity. So I'm sorry if I took a long time. I'll just conclude by saying that, as I said in the beginning, and which has been the origin of intellectual property rights, particularly copyright, we must always keep in mind the human-centered approach and how artificial intelligence protected or prohibited by copyright and intellectual property is controlled and regulated in a way to serve humanity and not to destroy humanity, and to try to safeguard the future generations from any kind of encroachment or infringement on their human rights and on their freedom and liberty. Thank you very much. And I'm very happy if there is any question to give you further information.
Hello, everybody. Let me introduce myself a little bit. That's me. So I'm an attorney in intellectual. I've specialized in intellectual property law, and it's been about 23 years of my practice. Did my master's from New York as a Dean Scholar. Worked with an organization known as the World Intellectual Property Organization, United Nations. Worked with Amarchand Mangaldas, one of the biggest corporate law firms. Then moved in-house with Goldman Sachs, and recently with Cisco Systems, a general counsel for a European major. At present, I'm a practicing counsel in the Supreme Court and Delhi High Court. So this is a very interesting topic because this is still an area which has to be demystified. You really have to understand how the synergy between IP and AI works. Because for IP to be recognized, a human intervention is very important. That's the must, that's the best part of it. IP as such, let me just explain what intellectual property is all about. Intellectual property law is a negative right, all right? It prohibits others to use the creation of idea that you have in terms of patents, copyrights, trademarks, design. So as such, it's a negative right. And AI, for that matter, is human intelligence exhibited by machines. That's the language. That's the definition of AI. So on the face of it, AI cannot be looked at as a patent holder, because a lot of cases have been coming up in the U.S. I think the Southern District of California just looked at a case where a patent infringement matter was filed by Qualcomm against Apple, where it said Qualcomm sued Apple for infringing upon its patent. When Apple looked at the whole matter and it went to court and it said, no, I have not infringed on their particular patent because this was a patent that was created by an AI, all right? So that's not a human inventive step that has taken place. After a long discussion in the court decided that because it was a part of a patent which was created by a human, this can be also looped in, and Apple had to pay a lot of sum to Qualcomm for infringing the patent. So understanding intellectual property law and understanding how IA is going to define it, or how IA is going to, in some ways, aid to intellectual property law. Patents, just going through the definition of patents, be it the USPTO, be it the EPO, which is the, the European Patent Office, or be it the Indian Patent Office. We have a specific regulation where it says that human inventiveness is very important. It has to be created by human. So this is a scenario which will create a lot of issues, because a lot of technology or a lot of algorithms are being created by AI, which does not have in any way human interaction or human intervention. So who is going to get the patent for it? So that's still a scenario which has to be looked at. The second scenario is the copyright issues. There are so many copyright copyright infringement matters which are going on. Take, for example, the Cambridge Analytica, the famous Facebook case where a lot of information was shared without seeking consent from any of us. So those are the areas where a lot of data mining goes in. So a lot of data is being used without consent. And if original copyright is being created, who is the author of that copyright? Who owns the copyright? Because can a machine own that copyright? No, it can't. So who owns it? That has to be demystified. So going through that definition, an engineer or a data mining expert, will he hold that copyright? Because even though he's not done anything for it, but it still fed the information to the computer for doing that. Then there are issues with regard to design. I think there's a lot of original designs that are coming in very recently. When we talk about NFTs, that's the non-fungible tokens, which are copyrightable in some scenario. So these are issues which still have to be looked at. There's still no clarity. As lawyers, we still don't have any clarity because the courts still are working on it. So there's a synergy, there's a positive, these are the negative synergies, but the positive synergy is that it's really helping, AI is really helping intellectual property grow in a scenario that it's making work easier for attorneys. You have a lot of documentation which are done by AI in a span of 1 hour. If you give it to someone else, if you give it to a particular contracting agency, or if you give it to a particular paralegal to do it, maybe they'll take a month to do the same work. So AI is certainly complementing in certain scenarios. Other than that, it's certainly helping a lot of individuals to manage work by their own. So there's certain amount which, there's certain synergy that goes in, which is a positive synergy, but on the other hand, there are some negatives to it, because intellectual property right is a creation of mind. If a mind cannot be attributed to a machine, so that's extremely important. The last aspect that I would like to talk about is the open software, or the open, the part where we're talking about open source software. Open source software does lead to a lot of issues with regard to open source for the benefit of the society. That's what open source is. I mean, if you use the algorithm and you create your own program out of it, you need to give credit to the open source from where you've taken it. But in AI, it's very difficult to attribute that. It's very difficult to attribute that you've used that particular open source algorithm, and there is commercial value to it. So these are the areas where it still needs to be addressed. There are few issues which are being addressed in the European courts or in the US courts. In India, it's still the nascent stage, but we'll be adopting the rules of the DPA very, in a span of certain months. Once that comes into place and the rules come into place, the judges will have to train themselves, and the lawyers have to do a lot of precedent hunting so that they can present that in front of the judges. That's about it. If you have any questions specifically with regard to this, I'll be very happy to answer them. All right, thank you.
So thank you. I'll go next. So I'll share an example of how AI is helping in IP. So recently, one of our patent application in US, we got a rejection. So this patent application was filed in various other jurisdictions, Canada, Europe, and some other, even China, India, Japan. So this patent has been granted in most of the geographies. And in US, we got a office objection citing a prior art document, which says, based on that, is cited that it's a non-obvious. So invention is non-obvious. So what my attorney did, he shared me a PDF document generated from an AI tool about the examiner. So his profile, what he has been doing, what kind of objections he has been raising. So from his history, we came to know that it's around 40, his grant rate is 45%, and the kind of document he has cited, it's a very cleverly written document which says that everything can be made by all the permutation combination. But when they gave an example, it's citing that these are the challenges, and to solve this, this is what you can do. So what document is teaching is totally different what they have written, explained in their descriptions. So, but examiner has cited it. And from that AI report, it came out very clearly that after what stage and what are the considerations the examiner has taken for the granting patent. So one thing was very clear that he relied on the experimental data, not on any argument. So for us, as a tool to protect our own IP, this AI tool is very helpful that at least now we understand that if we have to make a submission, so we have to rely on the kind of evidence we have disclosed in the patent application and what additional scientific evidence we have, what document is teaching and what actually happens, so that examiner takes into consideration. This is one of the positive thing what AI can help us in protecting our own IP. Other than now people are coming and saying that yes, they can get an idea and whole invention and file a patent application. So sometimes it sounds very weird to me, because if you go for a real patenting process, actually the field I come from, you cannot get a patent just by what you will get an idea, you get a theory. But to get a patent, you need to have a best mode of working an invention. So it's your AI tool is not going to give you mode of invention best mode, so experimental data evidence that you have carried out. So yes, but what is going to help us? It's going to help us on the accelerating our innovation process. So if you take the drug discovery process, so mostly the drug discovery process has heavily relied on the in silico, means based on the computer, using computer tools, so algorithm and all those things. So because there are hundreds of compounds and molecules which can target a particular receptor, so they heavily rely on that. So in that process, AI, I think, would going to play a major role and going to help speed up the drug discovery process. And there are various other tools like new era of gut microbiome, so their prediction of the AI tool may be helpful. But at the same time, when we see that use of AI for other human purposes, so there are a lot of concerns, a lot of debate, and other use of data which AI is using for training itself and getting their own benefits, so that IP concern is there. So recently there was a question to the Union Minister of State for Commerce and Industry, Sri Som Prakash. So in Rajya Sabha, so he gave a written reply to that. Somebody asked that whether are we going to create a new form of IP to protecting the give artificial intelligence protection. So he gave a reply that our Copyright Act per se protects the AI related inventions generated by AI. So any exemption has to be there, so that has to be there as per section 32 of the Copyright Act. So I think for us at present, I think that's a very good guidance and understanding that if AI is generating something, what it holds the value, whether it can be, somebody can say that he should get, AI should be an inventor or not. Because your section 32 of Copyright Act talks about the exemptions. So whatever the exemptions are available in the Copyright Act. So it means whatever AI is giving us, it's an exemption. It's as per Minister's reply, it's an exemption. That's what we need to consider. Beyond that, AI has to have a license from using the data. Yeah. So that's my take on that particular from that reply. And challenges, I think that challenges, biases, and all those things going to, if you use two different AI tools for the same query, you will get two different replies. So that biases are there, so which one is correct, which one is not, so that human ingenuity and judgment is going to play a role, so that's going to continue, there's no question about it. And data privacy, it's that in previous session, I think it was discussed in much detail that what is personal data and what privacy we should have, whether it's really there going to be privacy or not. So it's that's also evolving area. And with this, I would like to end my talk. So if anything else is there, if somebody would like to ask any questions or any.
Question for the creator industry. Like soon there has been protest in the US that US filmmakers and heroes were protesting that AI is going to replace them, right? The similar question that how are we going to form a foundation for it? Like very soon, like for example, James Bond, he will, maybe he will die, but after 50 years of time, we can use him for the next 200 years of time, right? So who is going to lay down the foundation of these new emerging areas in the creator industry? And the second thing, for that NFT as well, right now, some celebrities are experimenting with NFTs. They are going to voicing their voice, there some of the photos and all sorts of things. But what should be the benchmark or the foundation for it? Yeah.
All right.
And then another question was that there would be from the smart contracts, that I will going to ask from the blockchain thing. But once we'll have smart contracts in a very full-fledged way. Right now it's on the nascent stage since last 5-6 years. With time it will get evolved. And I'm very much promising towards that, that after 5 years or 10 years of time, we would be not be needing so many number of tribunals or arbitrators. Smart contracts will itself has so many detailed clauses, so many detailed things regarding payments also we can, that will have its own escrow account, and according to the clauses it will get executed. So I'm asking for the future perspective, are we going to reach that, or it's just a kind of speculation?
All right. Thank you for the 3 questions. All right. They're good questions to understand for everybody out here. First question you asked about the actors and being replaced by machines. That is going to happen. That's only, a phrase of time where that will. That's the main concern that most of the present so-called thinkers, the billionaires, are thinking about. That machine is going to replace humans, and that will happen in a scenario of time.
Also preserve human creativity.
Yeah, so that's the reason. That's how intellectual property comes into being, and that's the talk that I made earlier, was that intellectual property specifically gives credit to human mind and human creativity. We cannot give creativity, we cannot address the same aspect of creativity with with non-humans. So machines, they don't have creative sense. Humans are providing them with data in order to come out with the whole, algorithm or their own synergy. So for creativity being, the credit of creativity being given to machines will never happen. So that's something that intellectual property addresses. It's still in the nascent stage of addressing it. European Union has come up with a draft. The implementation is going to happen. So is the implementation in India going to happen. So are we going to have a separate law which takes care of artificial intelligence, or are we going to juxtapose that with the present Personal Data Privacy Act? So that's a scenario that we are going to talk about. The NFTs. NFTs still pose a lot of difficulty because, NFT can be replicated very often. Anybody can generate the NFTs. If I've looked at a picture, I can right-click it and generate my own NFT. So that's a scenario which it's still in the nascent stage. So if I have an NFT and if I'm selling it to you, who holds the copyright for it? That's something that has been debated quite often. The copyright is still with me because I'm the author of the NFT. So if you go to court for it, even the court will have difficulty in addressing it. So that's a scenario where you have to address how the copyright is transferred. Am I transferring the full copyright to you, or am I keeping the copyright for myself? So that's the answer to most of your questions. The last question of smart contracting. Yes, this fully automated. Yes, and that's happening. That's very much happening. The previous organization that I worked with was Cisco Systems, and that was highly technology driven. So as a lawyer, I did not have to hire a large team to do a lot of the contracting issues or the delta view issues where I'm looking at a contract which had gone on for past 10 years, and I'm not aware of it because I wasn't there 10 years back. But just because of the AI-centric, I was able to look at it and I was able to compare it so that I don't have any issues when there's a merger and acquisition going on, when there's due diligence being looked at. Because due diligence poses a lot of questions. If you're going for an acquisition, I think due diligence, and that's where AI helps. Because AI will counter all those issues that may come up during litigation. So that is certainly a helpful scenario with AI. All right.
Maybe
Sure.
I can add.
Yeah, sure.
If you allow me, I'll just add one remark. I think that, as I mentioned already, the question is, I mentioned about UNESCO, but in European Union, you mentioned about US, European Union, there is a huge agitation almost among the cultural art, cinema, film, music, etc. workers, and the violation of their intellectual property rights by big tech giants. And for this, that European Union adopted Digital Services Act last year, which I had mentioned. As far as US is concerned, there is a case I would like to cite where the US court said, I quote, "Work created in absence of any human involvement is ineligible for copyright protection," stating, and the court stated, this is very important, I think, idea, quote, "Human authorship is bedrock of copyright requirements." So I would like to put a question to you and make one more remark. The question is, of course, the automated system of machines is a human creation, but also machines created. We read a lot about how quickly chatbot can, artificial intelligence can summarize all your emails, create anything. And if you imagine in a very fast-paced manner, I would say you just have to push as somebody who wrote an article, just to push the button, and you get whatever you need in terms of putting together an essay. You can, there have been instances of writing poems and painting copied and all that. So there is a huge scope of digital devices working because it is rational and methodological in terms of data that is fed for being as much productive in technology as human mind, even faster. Because if you look into artificial intelligence, the way it's rapid, that is why it's used in the business and finance, is much more attractive than in other areas. But then the question is, what happens about infringement of intellectual property rights of many other right holders in the past whose proprietary rights were misappropriated by these big firms? I will quote the developments. For example, the largest issue is that of infringement which occurs when, and that is why we call it generative artificial intelligence, that it generates large language models and various ways in which they are, in terms of intellectual and rational thinking, even far ahead than human beings. And therefore, the generative artificial intelligence is trained, and what is the base of technical development? That is the training or used by popular deep learning models, which are generally trained on a very large database of media, and that is why this kind of training about database as such generates vast quantity of pre-existing human authored works, that is intellectual property protected works, and use inferences from training to generate machine learned ideas. Result is, since the process of assembling training data by these big artificial intelligence devices involves making copies of copyright works, it may violate the copyright holder's exclusive right to control the reproduction of their work unless the use is covered by exceptions under a given jurisdiction. And I think that is the issue to which there doesn't seem to be, to my mind, yet an answer. People are thinking about. But one question I'll put by concluding, on which you can reflect if you want. I at least find it very intriguing. The question is, imagining that machine created intelligent software, created something which is totally artificial, and copyright claims are made. Who will be the claimant? Whose rights will be protected? As I said, it will be employer, neural work. But if you look into intellectual property right, you create a right, you are right holder, and you have a right to defend yourself in case of infringement or encroachment. Now, there has to be somebody, something, natural person is supposed to be the person who is right holder of intellectual property, but even if you were to assume that it will be moral person, the question finally boils down to the fact that it is the companies which will be claiming on behalf of their work the proprietorship or ownership, because there cannot be another solution. So when you file intellectual property claims, all procedures you have to mention who is the author and originality and all those criteria, and the author, of course, is the company which employed the people to create as such.
I think I would like to address the last question, what you want to ponder upon to all of us. Who will be because there are debates across different courts, across.
Sorry, can I interrupt? I don't know if it's good. I'm sorry to interrupt. What I wanted to say was, assuming that a machine is allowed to, how will machine register?
Correct.
And how will machine claim?
I think that is a universal problem. Like in the COVID, there was a global problem, and the global cooperation happened. Then only, normally vaccine used to take 8 to 10 years of time. All of us, due to global cooperation, shared our data. We developed across the world within 8 to 10 months or 12 months of time. So similarly, in the space of either space, in the field of either space or AI, I think like in the human rights also, we have UNHRC declaration, and then according to it, all of the countries are adopting their own laws. So I think United Nations or all of the countries must having a common convention regarding AI. It is need of the hour. Then only we will be able to afford, because this is transboundary. Because one company sitting in India is making product for a boy in Chile, and he is generating some intellectual property based thing. If we don't have the common laws, then it will be a huge problem for all of us of the different courts of the different countries.
That's. Can you hear me? Okay, that's great. That's a good point, and that's a point that's being pondered upon at present. The World Intellectual Property Organization is having a lot of discussion with the member states, and the member states are all of us. So all India, US, UK, every member of the WIPO is coming up with their own white paper and they're trying to synergize AI and the IP, the scenario where we have a common legislation, like the World Intellectual Property has a specific legislation of copyright treaty. So everybody who's a member and who signed the treaty is part of that. So nobody can violate it, and it does lead to reciprocity.
Sorry, that is conventional knowledge.
That's the conventional knowledge.
Nothing to do with
That's the conventional knowledge, but as he rightly pointed out, that in terms of, if an IA has created a copyright or a patent, who claims it and who files an infringement claim against? So the employer definitely will do that, and because the AI does not have a legal standing in the court of law. Only the employer will have the legal standing in the court of law to represent that and to say that this is the IA that has been generated. Firstly, for the courts to address that, firstly they have to recognize that it's not, firstly they have to make sure that it's a human intervention that has gone in to generate that. If it's not, then they have to make sure that there is some kind of inventiveness that has gone in to generate that. So those are the scenarios that, yeah, sure, go ahead.
I'm a professor so I teach in one university, National University of Singapore. And here that is in Bangalore. My question is, a lot of people confuse automation and AI. See, for example, a lot of people confuse between automation and AI. Automation is an evolution process. AI is just the creative aspect that it can substitute for certain things and maybe do it better. I'm not so sure it's a bad thing, because it is almost evolution of the next generation. If we had a next generation who was smarter or was dumber, would that's just part of evolution, right? And secondly, it's like the laundry machine. It frees up a lot of time to do other things. So this technology is not even developed in one place. It's developed, distributed across. So why are we even, instead of enabling an ecosystem and seeing how it evolves, because you're not going to reinvent the wheel. It's going to evolve, take its own course. It's like nature. So why are we not letting nature take its course? And maybe we are looking at ethics of AI and a policy of AI really. I think the philosophy of those creating the AI is more subject to study and research rather than the technology itself, because technology per se is neutral. It's the development, is the usage of it. It didn't stop Einstein or Oppenheimer, so why would it stop in Altman or Musk? I'm saying that it has to evolve over time, and we have to take a generational view, not a generative view, but we have to take a longer term view of this, because if we stymie it too much, then it just cuts off something which could improve things for a later generation, and we are not the custodians of that. We're just trustees on this planet. Same with environment. A lot of technology and environment go together. A lot of AI could enable that environment. So who is going to balance all this? Because as we say in technology, what is the use case really? Who is the end user? The use cases could be multiple, but the source of technology is so amorphous right now, so global in its nature. So what are we even talking about at this point? Where is the policy and what is this ecosystem? So to map it, won't it take time, and do we not have to take a researcher's point of view also into account, because use cases could be multiple? Thank you.
I think you rightly pointed out. So most of the debate is happening not around what you're saying. It's around happening. People are talking about saying that AI is using a lot of data. So what they have developed, there is no question about those. Nobody is questioning on that. But to train that, lot of people's data, other people's, everyone's data goes in that. So when you say data, end of the day, companies make money. So it's not, they have not created it for humanity, for charity, to make money. So everybody wants their piece of cake in that. So it's all about that. So nothing bad. So yeah, so everybody is saying that if AI is using my data, so what? Is it, because data has been, your data has been allowed somebody to use for as the copyright section 32 of the Copyright Act. So it's as an exception. So for your personal use, if somebody so copyright says that if you are using it for commercial purposes, you should take a license. So, but AI doesn't take any license from anyone.
But it's also enabling us. It's also flowing back to it. You know, it's like environment. Humans don't pay the planet or the environment, but we're also sort of substituting planting trees. It's a two-way process.
In environment, I'll let you. There is a
The logic of it is.
there is an act called Biological Diversity Act. So there is a protocol called, it's called the Nagoya Protocol. It says access and benefit sharing. If you are accessing any biological resource, you are supposed to take a benefit sharing. So I think it's the same concept people are trying in AI. If I'm not wrong, it's my take.
Sure. Do you have a question? Go ahead.
Yes. Also, I don't think the debate here is about whether AI should exist or not. It already does exist. I think the debate is more about how the law can catch up and how IP can catch up to actually make way and make space for AI, right, to regulate AI. Correct. I think this is more a comment than a question, but I'd love to get your thoughts. And I think Sir touched upon it a little bit. But recently there's also been a debate in terms of recreating, say, a famous singer, for example, S.P. Balasubramaniam, who's a very famous South Indian singer. He's passed away in 2020, and then his voice was recreated for a song by a Telugu filmmaker, if I'm not wrong. And obviously the family took offense. And they sent a legal notice, and they sent a legal notice more from the perspective of wanting to give permission, right, and getting consent and compensation and things like that. But in terms of how this plays into, say, something like publicity rights, because actors like Amitabh Bachchan and Anil Kapoor have filed case laws to get recognized in terms of their voice, their image, their name, their likeness, which cannot be used without their consent, right? So in a situation like this, in today's time, when AI can be used to recreate these rights, I think the interplay of publicity rights, IP, AI has more prominence. And then the question is, whose permission do you need? Who owns the ultimate IP when such songs are created or anything along these lines? I would love to get your thoughts on how you see this playing out.
You want to go?
No, I fully agree with you. I think that is the issue. And as I have already mentioned, I agree. And I think that is the issue, that it is because of this big data and the resources the big companies have, digital giants have, they have huge amount. It's all a question of your data and cloud computing. So that you, on the one hand, you are, in terms of data, which is considered to be well today the richest, and on the other hand, you are practically outside purview of any state or authority, because it is question of what is virtual, what is in the cloud. And therefore, the questions that you raised, I agree with that. I think personally that the only solution would be if, and that is practically, I think at the present unimaginable, there were to be some supernatural international understanding and agreement with a convention to trying to defend some concepts which are floating from United Nations, such as digital commons. Now, how do you give shape to digital commons in terms of practical uses, but also in terms of intellectual property right? Then the whole concept of intellectual property right in the beginning at least was dissemination and international cooperation. How do you try to match the developments in artificial intelligence with some kind of international cooperation? That is the main issue between European Union and United States on the one hand, and between China and United States on the other. Because you have big poles of technical potential and growth, they are flourishing in their own ways, and there is hardly anybody capable of controlling. Most unfortunately, because the states as such are absolutely of no consequence, most of them, in front of these digital giants as such. And there is a lot of literature on that. So what should happen is building upon this concept of digital common goods, which has been given, some kind of convention could be formulated. UNESCO organized in 2023, last year, a big meeting to reflect over these issues and try to see how we can create a kind of intellectual property system under the aegis of United Nations and UNESCO, which would protect the copyrights as being which exist, and other copyrights which should be necessarily based, have their foundation in human information, human thinking, vis-a-vis anything which is artificial. And that I think is very difficult question, but probably this will be the only way. Otherwise, I don't see any solution if it is left to states as such. To me? To me? Yeah. Sorry, I am not in, I founded Right to Education program in UNESCO and later on in United Nations. But I had some interest in intellectual property rights, so I'll try to, please sit down. Please sit.
Sir, I would like to ask you, like, we've been talking about protecting copyrights.
Yes.
When artificial intelligence is creating, like, somebody is talking about actors' rights and all those. So, how do we create a balance and maintain a balance? Because we know there are countries, including India, where cloning is not allowed.
Slowly?
Cloning.
Yes.
So how do we have a balance between having artificial intelligence into developing like voices and other things and a creators' activities, and then also considering and maintaining the ethics about cloning? How do we have a balance between the two?
I do not know. Only answer I can give is what was already given by Ramesh and others, that we need to think, because of devastating impact, possible impact of artificial intelligence on humanity, we need to have some kind of treaty. The idea was floated, like nuclear test ban treaty. You discover, you know the story of Oppenheimer, who had absolute power in the US before World War II to invent nuclear bomb. It was invented, exploded, and when it was exploded, there is also a film which has come. He immediately had ethical concern and said, absolutely, I made the biggest mistake of my life. Please do not ever use it again. And the US government said, it's our business, not your business, to use or not use. Now, that went on. But then the nuclear test ban treaty came. Today, there are many countries, including India, which are nuclear power, but this, in practice, still is, apart from deterrent, doesn't have much of value as such. Although, it is the stockpiles are there. And therefore, what I would like to say is that there could be some kind of ban on artificial intelligence when it comes to, as you said, cooling, etc., and the other issues, but also the weapons that I mentioned, lethal weapons or bacteriological weapons, which are destructive of humanity. In other words, the guiding principle is same as I've had. When the technologies are promising, you foster them by way of some regime, but when they are vicious or even dehumanizing and consequences which are a threat to humanity, then you must try to, humanity should. There is a very great writer, I don't know if you must read, maybe Edgar Morin. He is French, and I know him, and he had been writing a lot. He's a very great intellectual thinker. He wrote recently a book on crisis of humanity, and he said that many crises, including these technologies, artificial intelligence and others, and we are living in a world which is heavily laden by big, he called multiple crises, where humanity, I'm quoting from the essence, humanity does not know, humanity with S, small s, humanity does not know how to become humanity, capital H. I think that is the issue, that we have to be human and then have a concept of humanity, Vasundhra, Kutunga, whatever concepts are floating here. There could be an element in that. But the important thing is, what is at stake for humanity? How humanity, under the aegis of some institutional framework like UN, could stand up to defend their own welfare, their own democratic values and other human values which are defended by human rights. I think that would be the only possible way. And that's something for which all governments and we all actors and other stakeholders should work. Thank you.
All right. Thanks for all the questions. I think they're the fantastic questions. All right, can I just answer her a little bit? It's a wild west at present. The AI has created a wild west in terms of there is no legislation, and as Sir pointed out, the specificity of having one particular legislation for all the member states, that's what the scenario is in give it another 2 years or something, because when I was reading through the white papers that are coming up, they're still synergizing the whole scenario, and maybe in a span of about a year or two, we'll have a composite legislation where all the member states sign it and you know, become a party to it. Just adding to it, there's a dichotomy in terms of understanding intellectual property law, because if you're looking at public good, AI does have a lot of public good. But then if you don't have a balance between public good and you know, the evil that goes in, there are a lot of infringement matters. But like for us, I mean for India for that matter, if you say that most of our intellectual capital was never under the patent regime. So most of our, you know, I'm talking about the earlier ages, where you're talking about the ancient ages, the Vedic ages, which was the richest part of it, because we believed in public good, and that's the reason. The Western countries did not believe in public good that much. They believed in the commercial aspect of it. They wanted to commercialize it. So if you don't have the commercial aspect attached to it, a lot of times public good does not help you. So it's a balance. You know, in India, we believe in public good. We believe in compulsory licensing, which is very good, but the West does not believe in it. So to keep up with the West, you need to have a strong regime which kind of provides you a guardrail in terms of intellectual property, but also in terms of adapting IA into intellectual property regime. Answering cloning, all right, yes, we don't have, there's restriction of cloning, the stem cell cloning. But you know, just looking at the legislation that goes in, even in the US, there is cloning happening very often. How, at this point of time, the world effect is that if you have therapeutic cloning, then that's perfectly fine. That's within the ambit of doing public good. But reproductive cloning is where it becomes a very evil area, because a lot of things can go wrong in that, which even the scientists cannot predict. And we as lawyers cannot predict that, because that may happen. So therapeutic cloning is definitely good for us and good for the community. So that's definitely a positive sign. Yes.
The concern of 140 crores Indians, because I'm not aware regarding the solution of it. That's why that's a genuine concern. What we have analyzed, there are three sub points of it, and then my question is that the concern regarding that. Recently only, we have seen that more than 100 plus top AI researchers around the world, few months back, have told the world that please stop using whatever the artificial intelligence based research is going around the world. So many prominent researchers have put that. The second sub-note is that the merger of information technology and the biotechnology is going to be very cautious if we are not going to the delves into it. And the third point is that the big tech giants, normally they are in themselves a supernatural country. They have that large size, that huge influence. And they don't even tell government at what capacities they are running the technology. They inform that we are at the basic stage, let us say delta stage. Even they have reached to the gamma stage then also. These are the three basic subnodes. And my concern is that what as a common citizen of India or any common society can do, whether we can file a PIL in the Supreme Court, because the law and policy is not going to the pace at which technology is going. So that's the concern, ki whether we can file a PIL regarding this, or whether Supreme Court can take a suo motu decision over it, ki there should be a committee or a body, a government-based body who should have, because previous below 2000 years, from now, since last 2000 years, we didn't have this scenario ever in our life. This is the first time when huge amount of data is flourishing in the world, huge amount of tech capabilities is happening, and the commercial point around the world is at the peak. So who are the commercial giants? They are going to reap benefit out of it. But if we don't have any such kind of committee or any such kind of things within our country, then it's going to be a matter of concern in next few years. Because if right now we'll miss the bus, I don't know what will happen. Yeah. So that's the concern, please.
All right. Do you want to answer? You are the right one. All right. All right. So that's interesting, and that's very much true in terms of there's still no. When the World Wide Web came into existence in the early 90s, people didn't know what's going to happen. We only had a very minuscule idea of what is going to happen. It's only when Google became a verb, Google is pretty much a verb now. So that's when we really understood what the World Wide Web can do. Because earlier, World Wide Web was only used for, specific knowledge gathering between countries. So if I have a specific security concern, I'll ask the specific country, all right, can you send it across? But now it's become like a giant library. You can do anything and everything with the World Wide Web. And that's the same scenario with IA because it's the nascent stage. But when OpenIA, when the inventors, of the founders of OpenIA or Elon Musk or any of these big giants talk about IA and it's generating commercial value, but also keep the guardrails. I mean, it's very important to understand that at this stage or at this 2023, we cannot really, we cannot foresee what's going to happen in the next 10 years. And that, it's very difficult to imagine that because there's still scientists at the, at DARPA, which is an organization in the US, they're still trying to understand it and what's the capability of AI. So before that, when you asked the question of having a PIL in the Supreme Court, well, that's too early at this point of time. Let the DPDPA come into existence and then see how it's going to, let the rules come into existence and let's see how it goes forward. Let's have some precedents in. And the Supreme Court, maybe in some time, will come up with a very standalone, precedents, which kind of gives you a guardrail, like we had the Aadhaar case, which Puttaswamy, where it did give a guardrail as to privacy is the innate, it's at, it's an innate conscious, or it's something that's innately inherent in our constitution. So maybe we'll have a precedent down the line, maybe give it another 2 to 5 years. We'll have a precedent which kind of gives you a guardrail for the next 10 years to come up. Any other questions, or we'll close the seminar? All right. I think that's the end of the questions. Thank you for your questions. You're a very lively audience. Thank you.